Hi everybody, April Jones here. I have been an attorney now over 33 years, and Jones Law Firm has been serving clients in Colorado, and we are in our 24th year. This webinar series, I'm so excited to bring it to you. It's helping us with our mission of education, enlightening our clients, and really helping you try to get to the next best place in your life. So we've got a lot of good information for you. We've got experts, we've got our team, we've got panel discussions, and so much more. So let's go see what this webinar is about, and I will see you on the other side.
Good afternoon. Thank you for joining our webinar, Breaking Free, Overcoming Economic Abuse and Financial Control in Family Law, put on by the Jones Law Firm. Today, we're going to talk to you about some specific subjects to help you identify signs of economic abuse and financial control, provide some strategies to protect your assets and your financial future, help you secure spousal support and understand your rights, and utilizing, if necessary, restraining orders and other legal protections to safeguard your financial interests. My name is David Collins. I'm senior attorney at the Jones Law Firm, been practicing attorney in Colorado for 20 years. I specialize in family law, including divorce, allocation of parental responsibilities, grandparent visitation, step-parent adoption, and all aspects of family law. I'm joined today by three distinguished attorneys at the firm. I'm going to ask them to introduce themselves one at a time. I'll start with Mr. Grant Bursick.
Good afternoon. My name is Grant Bursick, and I am a senior attorney here at Jones Law.
Haley Hollins.
My name is Haley Hollins. I'm also a senior associate attorney here at Jones Law Firm.
And Will Garvey.
Hi, I'm Will Garvey as well. I'm also a senior associate here at Jones Law Firm. Happy to meet all of you guys today and hopefully answer some of your questions.
Thank you. And so today we will answer some questions we've pre-drafted for you, but you are welcome to draft any question you have and put it in the chat. And if we have time, we'll try to answer your question. I will be dividing questions among the attorneys on the call today. And so we'll just jump right into it. Grant, what are some common forms of financial abuse that you see with your clients?
So some common forms of financial abuse that I have seen through the years are, first, removing money or assets from accounts. Another is to not allow one of the parties to the case to have access to the funds. And a third would be to put people on sort of a very strict budget that's not reasonable to allow the people to meet their needs. And then being very aggressive if that individual spends more than what's on their budget.
Thank you, Grant. Haley, what are some legal options folks have if they feel like the person they're divorcing has overwhelming control of the finances in the marriage?
Absolutely. First and foremost, when you're ever planning to file for a divorce, it's important to make an exit plan for yourself and to figure out what that can look like if you do expect your spouse to limit funds. Making an exit plan can be whether you need to kind of have an account in your own name to transfer funds in anticipation. Now, everything that you've got is going to be marital property, likely, that you will still have to disclose and to address in the divorce. But if you're concerned specifically about your access to those funds being restricted, making those actions prior to filing can be okay, but it's a very tenuous situation, and it's very important you contact an attorney to address exactly what you should or should not do if you're anticipating being cut off financially. Getting that advice up front can help you avoid issues with what actions you take later.
Thank you. And I should mention that today we're talking at a very high level, but if you have a specific case, we would love to talk to you. You can always call us 303-799-8155. We have a great team standing by to help answer your questions and, if necessary, to help you retain an attorney to represent you in your case. Will, can a party seek temporary orders from the court to get access to marital funds?
Of course, yeah. And in any situation where there's a major imbalance between the funds available to the parties, that's something that your attorney would advise. Specifically in those temporary orders, you can ask for maintenance. that could be used to, it would be temporary maintenance. That could be used to kind of keep you at the same level you were during the course of the marriage financially. Those funds could be used both for attorney's fees and for your regular everyday living expenses. Also at those hearings, you can ask for, if there really is a large discrepancy between the incomes, you can ask for the court to order that the opposing party be paying for your attorney's fees throughout the pendency of the case. Typically, that's something that the court will only do if there really is a large discrepancy. Imagine, you're the person who stays at home and raises the kids, while the other party is the one out as the breadwinner in the family who's making the funds and has access to all the accounts. You really see that often, again, where there's a big difference in the knowledge of the funds as well. And, one party is the homemaker and the other party controls all the finances, does all the investing, has the retirement accounts. Again, that's another situation you would see temporary orders where a judge would order attorney's fees to be paid, household expenses to be paid, and even temporary maintenance or child support too.
Thank you, Will. I should mention to the folks watching that in any divorce in Colorado, as part of the procedural process of getting divorced, once a petition's been filed, the court orders the parties to submit complete financial disclosures to each other that actually itemize every asset and every debt that the parties have. Grant, what are the remedies someone might have if they get financial disclosures from their future ex-husband or wife and they say, you know what, I don't think this is a fair and accurate depiction of all of our assets or all of our debts?
And that's a great question, David. It is not uncommon that after we receive initial financial disclosures that clients will come to me and say, I believe that my ex hasn't provided everything or is hiding assets. There are really sort of two main ways to address this. The first is you can propound written discovery on the opposing party. And the initial financial disclosures really give you just a quick snapshot of the accounts. You're really getting the most recent account statement, where with the discovery request, now you're going to look back 3 years and obtain 3 years worth of statements. The other major thing that you can do is seek court involvement. And what that looks like is a motion to compel. If you believe that the opposing party hasn't provided you all of the documents, you can go in front of the judge and say, Judge, there are these other accounts, no documents were provided, and I need you to enter an order compelling them to give me these documents. If the court agrees with you and enters an order compelling the production of those documents, and the opposing party still then does not comply with the request, then the court can start sanctioning the other party.
Thanks, Grant. Haley, there also might be two other options here if someone's withholding information, and I was wondering if you could talk about them. One would be to subpoena records, and the other would be to take the deposition of the opposing party. Can you describe those to the audience?
Absolutely. If you have no trust in what your spouse is telling you or producing, sometimes issuing subpoenas directly to the financial institutions where you know that they hold accounts can provide what we need in a more direct way, rather than continuing to request the documents to be produced by the party who is resisting that discovery process. Subpoenas can take a little bit of time, they can cost a little bit of money, but if you're pretty sure there's an account that's not being produced, oftentimes it's worth sending a subpoena out to see whether or not there are funds being held in that account or not. Additionally, oral depositions are incredibly useful in family law cases, insofar as that when you take the oral deposition of either party, what that looks like is kind of like a witness being on the witness stand, except instead of in a courtroom, you are generally in one of the lawyer's offices. There's usually a court reporter, or that it's being videotaped, and the other attorney is usually able to cross-examine either their client or the opposing party to pin down exactly what their truth is, where this money is spent, what they made, what their work history is, to get all of that sworn under oath in a way that is admissible in court, but also under the penalty of perjury, can be an incredibly useful way to get information out if you're just not sure what the answers are to a lot of important questions about your marital finances.
Thanks, Haley. And I'll offer an example. Sometimes we do get the original disclosures, and then we issue discovery, and we're supposed to get 36 months of savings accounts and checking account records. And we receive them, and we realize we got 34 months of records. and there's been 1 or 2 months deliberately withheld. And so that's when we might ask the court for permission to issue a subpoena to get the missing records. Often when those statements are withheld, they contain key transactions that the opposing party is really does not want the client or the court to be made aware of. Will, a question for you, and this is a question from the chat, so I'm just going to read it. I've been in a marriage for 30 years. I was a stay-at-home mom. I didn't work. I never accrued a retirement account. I'm getting divorced now. Do I have any right to a share of my husband's retirement?
The answer to that is yes, of course. Well, I should qualify that as well. It's yes, of course, but if the entirety of that retirement account came from prior to the start of the marriage and it stopped and didn't grow anything beyond that point, then no. But it's like any sort of marital properties, any property acquired during the marriage. And if the entire retirement account existed prior to the marriage and that was continued to be contributed throughout the marriage, you are entitled to the increased value of that retirement account plus any contributions during that time. In that situation, your husband may have been the breadwinner out working every day, but he also wasn't at home taking care of the home, raising the children. That's just as valuable in the court's eyes as going on and actually earning the money. Any marriage is a partnership. You kind of got to divide and conquer with all of the tasks that life's going to throw at you. And someone out earning a high income at work, it's going to take more time them there and away from the home. And he's going to want someone at home, raising the kids and making sure the house is nice and everything. So that's just as valuable as though earning income. So anything earned during that time is going to be completely marital property as well.
Thanks, Will. Grant, another question from the chat. Can I use money from joint accounts to pay attorney's fees, or do I have to use money that's not marital?
That's a great question. During a divorce case, attorney fees are considered a marital debt or a marital expense. So you can absolutely use money in a joint account to pay for your attorney. Understand, though, your spouse can do the exact same thing.
Thank you. And Grant, you mentioned earlier, so I'd just like to touch on a little further. How do you go about asking the court to order the other side to help pay your attorney's fees during a divorce?
Yeah, also a great question. There is a very specific motion that you file when you are asking for the other party to pay your attorney fees during the pendency of the case. And that's called a Rose motion, named after the litigant whose matter went before the Colorado Supreme Court on this case. And in a Rose motion, you specifically ask the court to basically have the other side pay your attorney fees during the case. And as Haley talked about, really and pragmatically, the only way the court is going to order that is if there is a large discrepancy in incomes and the parties have assets that are liquid. It's pretty difficult for a court to order someone to pay a large chunk of attorney fees, say $15,000, if there isn't $15,000 in the marital estate readily available.
Thanks, Grant. Haley, here's a question, and this actually is pretty common from the caseload here at the firm. What if my husband, we had this joint retirement account, it had $50,000 in it. I just found out he liquidated it and put it into a checking account in his name only. Is that still marital property?
Certainly. Well, presumably, I'm going to roll back like Mr. Garvey did and also say that presuming that account is a marital asset, the changing of the asset's location does not mutate or alter its characterization as marital property at all. However, if your spouse is cashing out retirement plans, there could be other implications beyond just tracing whether an asset is marital or separate. It could have many tax considerations and implications, and so it's incredibly important that if you do believe that your spouse is going to be transferring or alienating any funds, that you speak to the appropriate professionals who can give you some advice on that as well.
Thank you. And I'd like to remind our viewers, if you have any specific questions, please put them in the chat. Will, here's a question for you. I'm not legally married. We never got a certificate. We didn't have a wedding, but I think we're common law married. Is common law marriage legal in Colorado? And if so, do I have property rights in a marriage under a common law marriage?
So the quick answer to that is yes, common law marriage is valid in Colorado. There's a number of factors that go into that determination. The purpose of today's webinar is to talk about the financial side. So I won't go into all those factors for the common law, but just on a quick basis level, it's typically if there was some sort of ceremony, you live together, you've got some joint accounts, you've got assets tied together, you bought a house together, things like that all go towards supporting that consideration. And especially the longer amount of time, the more likely it's going to go into it. But if there's a determination that you are common law married, and that's the determination that you'll have to go in front of the court to make, if there is a determination there's a common law marriage, it's the same thing as though you were legally married. You had the ceremony, you got the certificate, and did all of that. So the same things that would have been marital property in a traditional type of marriage are going to be marital property in a common law marriage as well.
Thanks, Will. Grant, a question from the chat. My husband has restricted my access to joint accounts. Can I get my access back?
Yes. One, it kind of depends on how they have restricted your access to a joint account. If the account is truly in both of your names, you should contact the financial institution that holds the account because they can't prevent you as a owner of the account from having access to the account. Another way that you can regain access is to bring this to the court's attention. When a divorce case is initiated, there's a temporary injunction that goes into effect, and preventing a party to the case from accessing a joint account would realistically be in violation of that injunction.
Thank you. And Grant, since you mentioned it, can you speak broadly about the automatic injunction that goes into place anytime a petition's filed?
Yes, broadly speaking, the injunction prevents either party from removing either spouse or the children from any insurance that is covering the family during the pendency of the case. It also prevents either party from taking on new debts or encumbering property. And it really, the goal of the injunction is to sort of keep the status quo. No big purchases, no big spending, unless you have court permission or the other party agrees in writing. There's been times where I'm working on a case and during the pendency of it, someone needs to buy a new house. Well, that would clearly violate the injunction because it's a pretty significant purchase that's outside of the usual course of business. But they just emailed their spouse and said, hey, can I do this? And they agreed, and then it didn't violate the injunction.
Thank you, Grant. If someone does violate the injunction, what remedies might you have, Haley?
Certainly, if you violate the injunction or any other court order, often the remedy is to seek contempt from the court, or to at least bring it to the court's attention so that the court could issue orders or advisements to the other party. While if you're served with divorce paperwork, that automatic temporary injunction would be included in there. A lot of times people don't fully read or comprehend the papers that they're served with. And so if that is an issue, sometimes bringing it to the court's attention or seeking contempt if they are knowingly, willfully violating it after having been served, that's absolutely a remedy available to you. And it's a serious thing to be disregarding.
Thank you, Haley. I'd also like to note that while an automatic injunction goes into effect once a petition is served on the other party, any bad action people take in the lead up to the divorce can also be brought to the court's attention, and generally you can be made whole. So, and I'm bringing this up because there's a question in the chat that gets to this. The question is, my spouse says he will transfer the house into his brother's name so I don't get anything. We haven't filed anything yet, but can he do that? And if he does, will I completely lose out on my rights to the house? And the answer is no. You should have a right to have the court look back and say, this house was transferred in contemplation of divorce. Many times, the real estate in a marriage is not titled in both parties' names, and many times the loan is not titled in both parties' names. But any real estate purchased during the marriage is marital. And any increase on real estate value that was purchased before the marriage might also be marital. So it won't help your husband to transfer the title because the court can look back and see that it was marital property and transferred in contemplation of divorce. You may have to take some additional legal steps to make yourself whole, but you will have the opportunity to demonstrate to a court that a piece of property that is marital and was marital has been conveyed to somebody else simply to try to prevent you from having your rightful share to it. That said, if you know you're getting divorced, it's always better to get that petition filed, get the other party served, so the injunction is in place, so that if they do sell the house, you can actually argue to the court that they are in contempt of the court's order not to transfer or sell any property. Will, question for you. How do I begin the process of seeking spousal support and child support during proceedings? Can I get it during the proceedings? And if so, how do I go about it?
So yes, of course you can get it during the pendency of the case. There are really two routes. One, you can file a motion asking for temporary support and spousal and child support. And then typically, like we mentioned earlier, the court would set the matter for a temporary orders hearing where those things would be discussed. You would present evidence based off of your income, based off of the other party's income, and saying that, whether you have access to the finances or not, listing out your monthly expenses. Your sworn financials will really paint a good picture of that, because in there, I know we talked about how you would delineate all of your debts and assets, but you also delineate your income and any of your monthly expenses. And it kind of does a calculation for you in there of whether there's a shortfall from your monthly income versus your expenses. And that's something the courts would look to say, I earn, $2,000 every month, but my expenses are $2,500 for myself, my apartment, my kids. So they can see a $500 shortfall. So the court could then award spousal and child support to help make up for that shortfall during the pendency of the case. I should also mention that even if you don't seek temporary spousal support or child support, and you aren't receiving any of those funds throughout the pendency of the case, the court will often make a retroactive calculation for spousal and child support based off of what was not paid throughout the pendency of the divorce proceeding. So you can recover that even if you don't make that request early on in the case. You can still recover it later
on. Thank you, Will. I appreciate that answer. I'm going to keep working through the chat because the questions are now filing in. Haley, this question will be for you. I work 2 jobs to pay for her and the kids. He means, I believe this is a male saying for my wife and kids. And do both incomes get looked at for maintenance and child support?
Yes. The short answer to that is going to be yes. That income from all sources is considered when it comes to calculating child support and spousal support. And so if you are working 2 jobs, be prepared to disclose your earnings from both of those. That while that is also the case for your spouse, that if they are working, if they are earning funds, that their income is calculated into the overall spreadsheet. And so if your spouse is a stay-at-home person, it is very likely that they would be able to either be imputed at a minimum wage or even a higher wage if they're able to go back into the workforce in any way. And so all is not lost just because both of your jobs go onto the worksheet. There are ways to analyze what is exactly the right financial amount of support needed and other arguments that you can make to ensure that the right support order is made.
Thanks, Haley. And I'll just add to that child support and maintenance are a little different. And for child support, the first full-time job counts. But if you have 2 part-time jobs and they add up to 40 hours, then both jobs are going to count. But if you work 40 hours a week at one job and 30 at the second job won't be automatically counted as your income for monthly income. But Haley's right. The child support statute's broad. And even though it's not automatically counted as your income or monthly income for child support, there's another section of the statute that allows you to argue about the reasonable needs of the children because this person works 2 jobs and has this money. But more importantly, perhaps, is the idea that you don't have to keep working 2 jobs if you get divorced. The court's not going to order you to keep working 2 jobs because you may not need to work 2 jobs anymore if you are getting divorced and having one household. Grant, question for you. Just to confirm, this is from the chat, just to confirm, once I have filed for divorce from a spouse, they cannot take you off the insurance policy. And I'm assuming that's health insurance and auto insurance.
That is absolutely correct. Again, the exception to that is if you give them permission to remove you from insurance, or if the court enters an order allowing them to do that. I have never seen a court enter that order, but I've also never seen anyone ask. It doesn't really come up often in my cases.
Thanks, Grant. And I'll add that I have had several cases over the last few years where one party removed my client from health insurance and the court ordered them to reinstate my client on the insurance. And a court order ordering someone to reinstate them is a situation where the insurance company will allow you to be re-enrolled outside of the open enrollment period. One concern with health insurance is you have one window every year to enroll for it. The exception to that is court orders. If the court allows you to remove somebody from insurance, you can. Usually that's at the conclusion of divorce. Or if the court orders you to reinstate somebody on the insurance company will likely honor that and allow you to reinstate them outside of the open enrollment period. And we're almost out of time here, folks, but we'll just keep marching through these questions. And this is a broad question, Will. A lot is said about big spending. What is thought to be big spending in the scheme of daily life? I think the question's getting at is, now that I'm filing for divorce, are they going to say my vacation to Rio is an extraordinary expense? And Will, and I'll let you answer this further, but maybe not if vacations are the regular course of your family's business historically. Any thoughts, Will?
Yeah, so, for this question, I get to give a lawyer's favorite answer. It depends. I know you hear that all the time from attorneys, but it really does depend. What a big expense is, it would be nice if the court laid out what an exact definition of what that is, but it'd be difficult because a big expense is different from person to person. You got a household income where it's $1 million a year versus $60,000 a year. A big expense is going to be two different things for those. What really is, it's an expense outside of the normal course of your marriage. It's a violation of that status quo. It could be someone going to buy a new TV for their apartment because they've moved out of the marital house and they're going somewhere else. That, if it's a $2,000 TV, it could be considered a big expense, but it also, they might need a TV for their place, for their entertainment and whatnot. So it really is going to depend. It's what's out of the normal for a relationship. If, you buy a new TV every month, buying a TV that month isn't going to be what would be considered a big expense or out of the normal. A vacation as well, it can and it can't be considered not like a violation of the status quo or a big expense. Just depends on, if you never take a vacation a year and now you start taking them after the divorce is filed, that's going to lean more into it being a large expense or a violation of that status quo. So it's really going to depend on the context, and I think it's really useful to have that conversation with your attorney and bring it up to them in that situation, because they can really give you good advice on that for your specific situation.
Thanks, Will. And I will add that, if you're into dissolution proceedings, it's probably a good time to conserve your resources, and because you're going to be having separate households and separate sets of assets after they're divided. And so it's probably not the right time to spend extravagantly, as you'll need to regroup and live off of one income once you're divorced. I'm going to answer this next question. We only have time for maybe one or two more questions. This one is, my child's father has not reported an increase in income since the start of child support. I think he makes more now. How can I find out if I'm being paid correctly? And the answer is, you can ask for them to give you their tax return. Statute allows you once a year to ask for the other side's tax return and tax-related documents. They don't have a choice. They have to give them to you. And you can use that information to decide whether there would be a 10% change in child support. In Colorado, if there would be a 10% change in child support, then you can file a motion to modify it. For example, if you receive $600 a month in child support and you think it would go up or down by $60, then you have a valid basis to seek a modification of child support. The parties are obligated by law to exchange financial information annually at the request of either party. And if the father in this scenario won't provide it, you can simply ask the court to force him to produce his documents so you can determine whether there's a basis for a recalculation. And I am sorry, folks, there were more questions coming in, but we are out of time today. But we would be happy to answer your questions in a consultation. Again, you can always reach us at the Jones Law Firm, 303-799-8155. We look forward to hearing from you. And if possible, we look forward to representing you. Thank you and have a great afternoon.
Hi, welcome back. I hope you enjoyed this episode of our webinar series. You can reach us at denverdivorceattorneys.com. You can call us at 303-799-8155. We're on Instagram, Facebook, Twitter, TikTok, LinkedIn. You can find us if you need us, and we're here to help. Thank you and see you next time.